Good morning. On the occasion of the 106th birth anniversary of late legend Advocate Nani Palkiwala, an eminent and constitutional luminary, today is his 106th birth anniversary. On that, we are working on a corporate law Mahotsav. Today is the last day of that Mahotsav, and this is session 6th, which is basically dedicated to a topic that is a corporate matter on Supreme Court, CCI, company law, insolvency matters. Corporate matters in the Supreme Court involves appeals, constitutional challenges, and the dispute over corporate governance, insolvency, taxation, and regulatory actions like SEBI, CCI. These cases often stem from the High Court or the tribunal, respective tribunals, classifying laws on the director liabilities, merger, bankruptcy, oppressive of the stakeholders, and regulatory compliances. And the key examples are like IBC binding rules, SEBI matters. The Supreme Court ruling set precedents for the lower courts and the tribunals like NCLAT or NCLT, or CCI, influencing companies' law interpretations and reforms them. Today we have our esteemed guest, Advocate Jaiprakash Somani. He has a 30 years experience in a legal field, starting from the district court to the Supreme Court. He has written more than 65 books on different matters of civil, criminal, property, bail, consumer protection acts. These books are available on the Amazon and Flipkart. Over to you, sir.
Thank you. Thank you, Manoj, for your kind introduction. Welcome, friends, for this corporate law Mahotsav, sixth day. Today, we'll see the corporate matters handled by Supreme Court in CCI matters, in company law matters, and in insolvency matters. So I have prepared 3 blocks on these 3 CCI, company law, and insolvency matter, which Supreme Court handled that matter with its case laws. So let me share you the screen. Yes. So friends, in Supreme Court, statutory appeal is also there from company law to Supreme Court, company law to NCLT, NCLT to Supreme Court. Then SLP can be filed in Supreme Court. And if national importance issue is there, then writ petition and under Article 32 can transfer in Supreme Court. Okay. Now, other jurisdictions Supreme Court have, that is transfer jurisdiction, advisory jurisdiction to governor, advisory jurisdiction to the president. Okay, read jurisdiction, then appellate jurisdiction, then review jurisdiction, then curative jurisdiction. So there is my different videos on Supreme Court jurisdiction and Supreme Court, how Supreme Court handles that matter. So today we'll stick with the corporate law matter handled by Supreme Court in these 3 categories. So first is we'll see CCI, corporate matters handled by CCI. So this is a blog, just I have written it. So corporate matter handled by the Competition Commission of India, CCI, by Supreme Court. Just a minute. Yes, this. Corporate matters of CCI handled by the Supreme Court of India. The Competition Commission of India derives its power from Competition Act 2002. So 2002 का जो Competition Act है, इसमें Competition Commission of India की स्थापना हुई है. Okay. The Supreme Court plays a crucial critical role in deciding appeals and clarifying the legal principles where CCI's orders are challenged, especially on issues involving abuse of dominant position, Section 4 of Competition Act, anti-competitive agreement, Section 3, jurisdiction and scope of CCI, application of competition law to public undertaking and statutory bodies, procedural and substantive competition laws, doctrines. The Supreme Court's intervention ensured uniform interpretation of the Competition Act and protection of market competition in India. So what is exactly the role of Competition Commission of India? What is the spirit of competition law? So main spirit is, in India, there should be a competitive environment in business, in enterprises. So one should not have a dominant position in market. Otherwise, if anybody is establishing his dominant position, then he can misuse his position and will general public will suffer because of that. मोनोपोली क्रिएट हो जाती है और फिर लूटा जाता है फिर लोगों को मोनोपोली क्रिएट करके. तो दैट शुड नॉट हैपन. सो this law is there, and these sections are very important. Section 4, Section 3. Okay. So step by step, I'm elaborating you with case laws. Abuse of dominance. So there should not be a dominant position. So abuse of dominance, Section 4, Competition Act 2002. Leading Supreme Court judgment, Competition Commission of India versus Scott Glass India Limited, India Private Limited, 2025. This is the latest judgment. The Supreme Court held that Section 4 does not per se prohibit dominance. Rather, the inquiry must focus on effect of conduct and whether it harms competition. Simply having a dominant position is not an offense. The conduct must be shown to distort market competition. The key takeaways of this landmark judgment: dominance is not unlawful unless it is abused adversely affects competition. So dominant position should not be adverse to the competition. So this is the main issue which Supreme Court have advised. Then an effect-based analysis is mandatory to determine abuse. This significantly tightened scrutiny over how CCI formulates findings of dominance and abuse. Then application of competition law to government entities and statutory monopolies. The Supreme Court clarifies in Coal India Limited versus CCI 2023-2024 contest, the Supreme Court held that public sector undertakings PSU and statutory monopolies like Coal India Limited are not exempt from the Competition Act. They are also in the surveillance of the Competition Act, merely because they are constituted several common goals. If such entities are engaged in commercial activities and alleged to engage in anti-competitive conduct, CCI has jurisdiction to inquire and take action. Legal significance of this case law: this decision affirms CCI's reach over all market participants, including government-owned enterprises, when acting as a market player. Then next segment which Supreme Court handles in these CCI matters, that is jurisdictional limits of CCI. While the Supreme Court has not yet produced a major binding verdict on this in 2025, the High Court ruling, which often reach SC, recognize that patent licensing patent licensing disputes cannot be routinely investigated by CCI, where they falls entirely within the ambit of Patent Act 1970. This reflects emerging limits on CCI's reach into areas governed by special statute. Implication: the matter involving licensing conditions solely governed by intellectual property law may not be appropriate for CCI investigation, a principle likely to be scrutinized by the Supreme Court if such appeal arises. This is just a advice of the High Court, but Supreme Court has not yet decided it. Then scope of competition law, jurisdiction, and civil courts. So while not Supreme Court judgment, High Court decision which can be revived by the Supreme Court have held that civil court lack jurisdiction in dispute that involves abuse of dominance or other competitive law causes of action. As the Competition Act, particularly Section 61(2), outs civil court jurisdiction in favor of CCI proceedings. So there is no civil court jurisdiction for this Competition Act matter. Only jurisdiction is under CCI. And after CCI, appeal to NCALT, and after NCALT to then Supreme Court. This reinforces the idea that competition matters are best adjudicated in specialized forums, a principle that the Supreme Court has supported in the broader context of specialized tribunals. Then CCI enforcement in digital and platform markets. A recent corporate competition action by CCI against big tech, for example, big tech platforms such as Google, WhatsApp, Apple, through now always at culminating this in the Supreme Court judgment, are significant because appeals from CCI as well as interpretation of digital market abuse are likely to reach the Supreme Court soon. Examples of high-profile CCI action, potential Supreme Court appeals. 1. Google and Android Play Store cases. Large penalties imposed for anti-competitive practices, pre-installation, exclusion of competitors, etc. WhatsApp Meta 2021 privacy policy case. CCI fined Meta for abuse of dominance under Section 4 for imposing unfair conditions. Appeals continue before NCLT and likely to reach the Supreme Court. Apple App Store investigation. CCI probing alleged abuse of dominance in app payment policies. Constitutional and jurisdictional challenges are being pursued in the court. Why this matter? The Supreme Court will have to engage with new age competition laws question like, does the data privacy conduct constitute anti-competitive abuse? Can digital platform market power be regularized under Section 4? How should global turnover be used in penalty calculations? Recent legislative changes have added even more judicial reviews issues concerning penalty provisions. Procedural and natural justice principles. In competition appeals, the Supreme Court emphasized fair hearing and procedural fairness, correct appreciation of evidence, proper application of legal definitions of dominance and anti-competitive agreement. Such procedural fairness principles historically feature in competition appeal and give guidance on how CCI's investigative and adjudicative processes are to be revived on appeal. Other notable competition law cases likely to reach in the Supreme Court. While not yet Supreme Court decision, these CCI cases shape the appellate trajectory. Make my trip, go IBBO, and OYO case anti-competitive agreements, cartel, vertical restraint issues. Maruti Suzuki dealer price case, resale price, maintenance and vertical restraint findings. These matters involve corporate competition, conduct, and can be expected to raise substantial appeals before the Supreme Court on interpretation of Section 3 and 4 of Competition Act. Then statutory provisions often interpreted by the Supreme Court. Section 4, prohibition on anti-competitive agreement, includes cartels, price fixing, RPM, market allocations. Section 4, prohibition of abuse of dominant position, requires conduct that affects competition. Dominance alone isn't enough. Section 19 to 27, investigation and adjudication power of CCI. Section 53T, appeal from NCLAT to Supreme Court. Section 53M, powers of Supreme Court in competition appeal under the Act. Importance of Supreme Court review in corporate competition matters. Clarifies the substantive competition law principles, that is, dominance versus abuse. Defines CCI's jurisdictional scope, including applicability to public sector or public specific disputes. Ensures procedural fairness and natural justice in CCI action. Interprets interface between digital markets and competition law, and involving areas like to produce leading judgments. Addresses constitutional challenges or interpretation of penalties provisions, as seen in high-profile Apple cases. Conclusion. This is my concluding remark on this particular subject. The Supreme Court of India's involvement in CCI cases is a key component of India's competition law ecosystem. By interpreting Section 3 and 4 of the Competition Act, confirming CCI jurisdiction over various entities, and enforcing procedural fairness, the Supreme Court shapes how corporate conduct is regulated in markets. The court's jurisprudence ensured that antitrust enforcement balances market efficiency, consumer welfare, innovation, and business freedom. Thank you. With the grace of Lord Krishna, I am the panel advocate of CCI for Supreme Court. So we are regularly watching this matter in Supreme Court, handling this matter in Supreme Court. And Supreme Court is very cautious to handle any type of matter because their verdict will be implemented all over India under Article 141 of India, 141 of the Constitution of India. So our next part is corporate matter of company laws handled by Supreme Court. So company laws which matter, or company laws matter how Supreme Court handles. So this is my blog on that. In due course, I will publish this blog also. Corporate matters of company law handled by the Supreme Court of India. Key statutory framework. The Supreme Court adjudicates on company law issues arising under the Companies Act 2013, replaced the 1956 Act. Includes fraud and penalty, section 447, 448, and 451. Director duties and liabilities, section 166, 184, and 188. Operation and mismanagement, section 241 and 242. Ultra virus and corporate capacity, section 2, subsection 30, section 4, and section 179. Winding up and liquidation jurisdiction issues, section 271 to 434. Criminal proceedings bar, SFIO inquiry, serious fraud investigation office inquiry, section 212. Then corporate governance and minority protection, section 241 to 242. The Supreme Court's rule is to ensure uniform interpretation of these provisions across India and guard against misapplication by lower tribunal, NCLT, NCLAT, high courts, or executives authorities. Now first, fraud and director liability, section 447 and 448. Section 447, punishment for fraud. Section 447 of the Companies Act 2013 defines fraud by the company or its officer and provides for substantial penalties, including imprisonment and fines. Section 214, subsection 6, bar on cognizance without SFIO, serious for investigation office. Section 212, subsection 6, bars criminal proceedings under section 447 and offenses covered under the section 447, unless initiated by Serious Fraud Investigation Office, SFIO, or authorized government officer, which the Supreme Court has noted in earlier related disputes. Supreme Court guidance. Supreme Court has underscored the corporate fraud cases under the section 447 and 448 must strictly follow statutory procedure for investigation. That is, SFIO, ministry initiated complaints, and trial courts cannot take cognizance if the bar under section 2126 is attracted. Independent and non-executive directors cannot be held liable for company offenses unless direct involvement is proved. Very vital adjudication by Supreme Court is given in this matter. Because independent director cannot be held liable unless direct involvement is proved. I myself is a qualified independent director by the Ministry of Corporate Affairs. Clarifying director liability is in criminal corporate cases. Practical impact. Companies and officers can't be prosecuted on private complaints alleging fraud unless they satisfy procedural prerequisites and proper statutory complaint routes, protecting corporate directors from frivolous prosecution. Very nice decision. Then operation and mismanagement, sections 241 to 242. Operation and mismanagement provisions protect minority shareholders and prevent abuse conduct by controlling members. Key Supreme Court cases. Tata Sons Limited versus Cyrus Investment Private Limited, 2021 landmark case is this. The Supreme Court dismissed the allegation of operation and mismanagement against Tata Sons and its board, reinforcing that strategic business decision like chairman removal, do not automatically amount to oppression unless they show willful neglect or prejudice to minority rights. Legal principles, the court emphasized the business judgment rule. Courts should not substitute their commercial wisdom for that of the company's broad board unless the conduct is unfair, prejudicial, or in bad faith. Director and auditor liability. Independent and non-executive director protection. The Supreme Court recently ruled that non-executive and independent director are not automatically liable for company's default, that is bounced check or fraud, if there is no direct active involvement or knowledge of wrongdoing. Significance, this clarifies that the liability under company law must be tied to actual involvement in misconduct, not merely holding a board position. Auditor liability. The criminal appeal context, the Supreme Court has upheld that auditors may be prosecuted for fraud under Section 447 even after resignation, but only if the statutory conditions are complied with, enforcing the accountability of auditors for misstatement and fraud. Corporate governance and criminal procedure bar. The court has upheld that bail in fraud cases under Section 447 cannot be granted unless the two twin conditions, that is, government prosecution opposition and court satisfaction of no for future offense under the Code of Criminal Procedure are met. They underscore the seriousness with which the judiciary view corporate fraud under the Act. Then, fifth part of this presentation, winding up and liquidation jurisdiction interplay with IBC. While primarily under Insolvency and Bankruptcy Code 2016, the Supreme Court has dealt with related company law matters. JSW Steel Bhushan Power Case 2025. The Supreme Court struck down an acquisition by the JSW Steel of Bhushan Power and Steel on ground that the resolution plan and creditor action did not comply with statutory procedures, even ordering the company's liquidation before pausing the liquidation on review. Importance, although with the IBC, the decision also implicates the corporate governance, shareholders' interest, and secured creditors' rights, illustrating how company law principles like ultra vires of corporate capacity and fair procedure influence insolvency outcomes. 6. Company law and constitutional criminal interface. The Supreme Court has repeatedly stressed that company law is not isolated. It integrates with constitutional principle, that is due process, separation of power, etc., criminal procedure code, and statutory interpretation. As in fraud, jail bar context or director liability, the court ensured corporate law enforcement aligns with broader legal protections. So, company director को easily जेल में नहीं भेज सकते. That is the proper procedure. There is proper law because they are working on behalf of company. If really their intention is to deceive the shareholder, to deceive the general public, to deceive the stakeholder, and it proves that time they can be go behind bar. Otherwise, not. Key sections frequency considered by the Supreme Court. So there are two columns. One is section and another is subject. Section 447, punishment for fraud under the Companies Act. Section 448, false statements punishable linked with Section 447. Section 451, punishment for repeated default. Section 241 and 242, operation and mismanagement. Section 212, subsection 6, bar on criminal proceedings without authorized complaint. Section 166, duties of directors often considered in liability cases. Section 188, related party transaction occasionally litigated in governance cases. Recent and relevant SC trends in corporate law 2024 to 2026. The Supreme Court continues to refine director and auditor accountability in corporate governance. It ensures strict procedural compliance in corporate fraud and SFIO investigations. In insolvency linked corporate acquisition, SC emphasizes statutory safeguards and creditor interests. Exemplified by the JSW Bhushan Power matter. Judicial scrutiny for corporate litigation maintains the balance between commercial judgment and legal fairness in operation and mismanagement jurisprudence. Practical takeaway for lawyers and companies. Fraud cases under Section 447 require procedural rigor. Without authorized government complaints, criminal proceedings may be barred. Very good protection. Director's liability is not automatic. Culpability must be clearly demonstrated. Minority stakeholders' rights are protected, but courts will protect commercial decision absence unfair prejudice. In corporate acquisition and restructuring, the strict legal procedure and statutory compliance remain pivotal to judicial review. Conclusion. The Supreme Court of India plays a crucial role in shaping corporate jurisprudence by interpreting the Companies Act 2013 in harmony with procedural fairness, statutory safeguards, and commercial realities. Its judgments on fraud, director liabilities, minority protection, and criminal procedures in corporate context and governance have set binding precedents that guide that these precedents guides courts, tribunals, regulations, and corporations nationwide. So this is the second part. Now, last part of this particular sixth day, that is a corporate matter handled on insolvency law by Supreme Court. Corporate matters under insolvency law handled by Supreme Courts. So statutory context, Insolvency and Bankruptcy Code 2016 IBC. The Supreme Court's corporate insolvency jurisprudence primarily arises from these key provisions of the IBC. So, friends, just to give me a few seconds. With the grace of Lord Krishna, I am insolvency professional also. I'm handling as a IRP, RP, and liquidator in many matters, along with my advocacy, arguing counselship in Supreme Court of India. So we are practically implementing administrative way as a IP and IRP and liquidator. And while we are handling this matter in Supreme Court, so our role is as a arguing counsel. So how Supreme Court is handling these insolvency matters, and which good precedents Supreme Court has developed till date. The Supreme Court's corporate insolvency jurisprudence primarily arises from these key provisions of IBC. Section 7, application by financial creditor. Section 9, application by operational creditor. Section 10, corporate debtor application. Section 14, moratorium. Section 30, approval of resolution plan. Section 31, effect of approval resolution plan. Section 33, liquidation. Section 43 to 51, avoidance transaction. Section 60 and 60 to 62, adjudication and appeals. These sections collectively form the corporate insolvency resolution process framework under this code. The Supreme Court on integrity of CIRP as a complete code. Muhammad Enterprises, Tanzania Limited versus Farooq Ali Khan and others, 2021. Core holding. The Supreme Court held that the corporate insolvency resolution process, that is CIRP, under IBC is a complete statutory code. The High Court cannot interfere under the Article 226 when specific remedies exist within the IBC. That is, appeal to NCLAT and Supreme Court. Key principle, courts should not sidestep the court's structural appeal hierarchy when adjudicating IBC matter. This reaffirms earlier jurisprudence that ABC's appellate process NCLAT to Supreme Court is exclusively for corporate insolvency issues. So no one is allowed to go after NCLT to High Court and then High Court to Supreme Court. No. After NCLT, you should approach in appeal to NCLAT, and after NCLAT, you should approach to Supreme Court. Second, Supreme Court on Bhushan Power and Steel Resolution 2nd. Kalyani Transo versus Bhushan Power and Steel Limited, JSW Steel. This dispute becomes among the most significant IBC corporate matter in 2025, with the Supreme Court twice reversing its own outcome and issuing equivocal directions. May 25 judgment and historical intervention. Supreme Court set aside an approved resolution plan for Bhushan Power and Steel Limited BPSL even after approval by the COC, NCLT and NCLAT for serious statutory non-compliance and misrepresentations under IBC. The court ordered liquidation of BPSL under Section 33 and under Article 142 to effect comprehensive relief, including directing return of fund to creditors, emphasizing that statutory compliance and transparency are not negotiable in corporate insolvency. Very good decision. Subsequent review and clarification. Facing economic and investment concern, in mid-2025, the Supreme Court agrees to review the order quashing the JSW acquisition and set the matter for fresh consideration. This reinforces that even appeal level decisions can be reconsidered if precedent and legal consistency weren't adequately addressed. Legal significance. This case shows the Supreme Court's willingness to scrutinize COC's decision and approved plans not on commercial wisdom alone, but on statutory and procedural integrity, especially regarding the Section 29 eligibility, disclosure norms, and compliance. The lawyer who is regularly handling matters in NCLT and CLAT and in Supreme Court of insolvency matter, my appeal read this case law in detail. So you will get very, very nice ideas and very, very good input you will get. Then section 3, that is the part 3 of this presentation. Finality of approved resolution plan. Case law is Vaibhav Goyal and versus Deputy Commissioner of Income Tax and others, referred in 2025 jurisprudence. The Supreme Court reaffirmed the clean slate principle. Once a resolution plan is approved under Section 31, all claims against the corporate debtor that aren't included in that plan are extinguished. Extinguished means खत्म हो गया. So after approving the resolution plan by COC under Section 31 and it is approved by the NCLT, then all the claim against corporate debtors that aren't included in the plan, if that claim are not included in plan, they are vanished. They vanished, they are extinguished. This includes statutory dues such as income tax and other pending demands not provided for in the plan. This provides certainly for investors and resolution applicant that post-plan approval, the corporate debtor is free for legacy liability not expressed covered. This is the main spirit of the code. So stress asset should be stressless and that particular fellow should be free to do his next venture in commercial field. So this is the main spirit of this code, IBC. Supreme Court on Committee of Creditors, COC powers. Piramal Capital and Housing Finance Limited versus 63 Moons Technologies Limited. The Supreme Court upheld the commercial wisdom of COC when it approves an unusual resolution plan provision, where recoveries from avoidance transactions were allocated to financial creditors and not to other stakeholders, ruling that tribunals like NCLAT and NCLT overstepped their jurisdiction by modifying the plan. Takeaway: court respect the commercial discretion of COC as long as statutory requirements are met. Fifth part, Supreme Court on scope of IBC remedies versus other forums. The Supreme Court has consistently held that IBC provide an exclusive statutory regime for resolution and related disputes. High Court should refrain from interfering with CIRP progress if there are adequate alternate remedies available within IBC. COC objection. After COC objection, matter should go to NCLT. And after NCLT, matter goes to the NCLAT. And after NCLAT, matter comes to Supreme Court. This protects the IBC's self-contained code integrity and prevents collateral litigation, that is, writ petition under Article 226 of Constitution of India. 6. Supreme Court's position on claims extinguished after plan approval. The Supreme Court's confirming The clean and state doctrine noted above is a cornerstone in insolvency jurisprudence because it ensured that corporate debtors can restart operations without past encumbrances, encouraging investment and revival. 7. Supreme Court on personal claims and entity identity. Supreme Court rejects insolvency plea against Electro-Steel Casting Limited ECL 2026. In early 2026, the Supreme Court dismisses. We are recording this video, we are giving this presentation on 16th January 2026. This is the 1/6th birth anniversary of my Guru Nani Palkhiwala. And we are covering 2026 judgment also in this presentation. In early 2026, the Supreme Court dismissed a plan by UV Asset Reconstruction Company seeking to trigger insolvency against ECL on the basis that the approved resolution plan for Electro-Steel Steels Limited has extinguished all concerned associated claims. The Apex Court upheld the enclad view that resolution plan approved under IBC barred further claim against guarantors and elsewhile promoters. This reinforces the principle that a fully approved plan is a final and precludes derivative insolvency action on extinguished liabilities. Key IBC sections under Supreme Court review. There are two columns, section and subject. Section 7, admission of application by financial creditor. Section 9, admission of application by operational creditors. I have my different videos on this section 7, section 8, section 9, section 10 also. Section 14, moratorium during CIRP. Section 29A, eligibility criteria for resolution applicant. Section 30, submission of resolution plan. Section 31, effect of approved plan and finality. Section 33, liquidation commencement. Section 43 to 51, avoidance transaction. And Section 60 to 62, adjudication and appeal hierarchy. Emerging issues not yet fully settled, like SC impact cases. Moratorium versus criminal liability. These issues are not settled by Supreme Court yet. High Court have recently held that director cannot use IBC moratorium to evade personal liability, that is check bounce under NI Act under section 138. Citing Supreme Court precedent, that is for example, P. Mohan Raj versus Shah Brothers Ispat and Rakesh Banot versus Gurdas Agro. Although not a direct SCE insolvency judgment now, this area could reach the Supreme Court for clarification of the several versus corporate protections under IBC. Clarification of personal versus corporate protection under IBC. Real estate and home buyer claim. While many issues around home buyer and financial creditors and real estate protect-wise insolvency have been elaborated in tribunals, that is, for example, Mansi Bar Fernandez versus Shubha Sharma. Further Supreme Court guidance is expected to consolidate these principles, especially the interplay of RERA with IBC. Conclusion: the Supreme Court of India have progressively shaped the jurisprudence of corporate insolvency law by balancing statutory fidelity to IBC with commercial realities. Commercial realities. Leading the Supreme Court judgment affirms that IBC is a self-contained and exclusive code for insolvency matter. Approved plan have finality, extinguishing non-proved claims. Commercial wisdom of COC is respected, but statutory compliance is paramount. Court should not undermine the statutory hierarchy of remedial mechanisms. Resolution plan approval required transparency, compliance with Section 29A, 30, and 31. These principles ensured that corporate distress resolution under the IBC is predictable, fair, and rooted in statutory law while being robust enough to address institutional and procedural gap. So friends, let me stop the screen sharing. So friends, this is the end of this sixth day. Now, on seventh day, we'll see the Nani Palkhiwala's contribution in Indian legal system. And I will elaborate that part in this segment, that legal as a legal numerary, how he contributed in legal system. Then books written by Nani Palkhiwala and books written on Nani Palkhiwala. I will elaborate that also. And most important, Nani Palkhiwala's argument in landmark leading cases of India. So in these three ways, I will elaborate. Last year, we have already taken 7 days webinars, which already on my YouTube channel on Nani Palkhiwala's arguments in different landmark cases. That is Keshwanand Bharti, detailed para which argument, which Nani Palkhiwala argued in the court, in Supreme Court. I have elaborated that. If you have time, just go to that videos also. Watch that video, listen that video. So you will get the how this luminary argues in Supreme Court, how they are giving references to different countries' constitutional principles also, how they are collaborating to these principles to the Indian context, and how doctrine of basic structure comes into existence. So everything you will get that. So on seventh day, we will see the Nani Palkhiwala's contribution in Indian legal system. Okay, thank you very much. Manoj, now you can conclude.
Thank you very much. Thanks all the visitors who has came for this particular webinar. Today we have the sixth day and the sixth session, which was basically corporate law in a Supreme Court. So as Sir has typically given the different points on which we can come to the Supreme Court, like constitutional challenges, either from the statute of the Company Act or from the SEBI Act or from the IBC. Then appeal from the High Court and the tribunals regarding the merger, acquisition, liquidation, and regulation penalties. Other cases involve the regulatory disputes that may arise from the SEBI, CCI, RBI, and enforcement and the interpretation of these statutes. Thank you very much, sir. Thank you to all. Thanks.
Thank you.